You know that old legal saying, right? That a grand jury would indict a ham sandwich if a prosecutor asked them to.
It's a classic, yeah. It
Mhm.
just means the bar for getting an indictment, that green light to actually take a case to trial, is usually set incredibly low.
It's a one-sided presentation.
Totally. It's the prosecutor's show. So getting a yes from a grand jury is, well, it's supposed to be the easiest part of the job.
Exactly. A rubber stamp.
Yeah.
Automatic. But this is where things get really weird. What happens when the Department of Justice, the one we're looking at right now in February 2026, can't even get that ham sandwich indicted?
Mm-hmm.
What happens when the most powerful law enforcement agency on the planet can't get a single vote from a room full of regular citizens?
That is the big question we're digging into today. And it's not just about sandwiches, though. Believe it or not, we will get to a literal sandwich later. It's about a pattern that some of our sources are calling a constitutional crisis.
Today, we're doing a deep dive into the current state of the DOJ under the Trump administration, and specifically U.S. Attorney Jeanine Pirro. We've got a huge stack of sources here. Reports from Democracy Docket, legal analysis from Above the Law.
News from Reuters and Homeland Security Newswire, and even transcripts from legal commentators like Glenn Kirshner.
And the picture these sources are painting is, well, it's chaotic.
It really is. I mean, you're
Yeah.
seeing accusations of weaponization, retaliation, and a justice system that is basically fighting a civil war with itself. You have the leadership pushing for these big prosecutions.
And the system itself, the juries, the judges, are just jamming the gears.
Right.
So let's unpack this. Our mission today is to figure out how a series of veiled prosecutions, and we're talking about cases ranging from high-profile senators to, yes, a guy who threw a hoagie, how all this reveals a huge battle between the DOJ's leadership and the system's own checks and balances.
And the best place to start is with the headline failure that just dropped, the case of the Democratic Six.
This story is just wild. So you have the DOJ trying to indict 6 sitting Democratic lawmakers.
And not just any lawmakers. We're talking Senators Elissa Slotkin and Mark Kelly, Representatives Chris DeLuzio, Maggie Goodlander, Chrissy Houlihan, and Jason Crow.
And the context here is super important, right? These aren't just random politicians.
No, not at all. All 6 of them are veterans or they're former intelligence officers. They've served the country in uniform. That's a key piece of this.
So, okay, your immediate thought is, if the DOJ is going after them, it must be for something huge.
Yeah.
You know, corruption, selling state secrets.
You think so. But no, it was video.
A 90-second video.
Ah.
I watched it for our prep, and it's pretty dry, honestly.
It is. It's basically them just reminding military personnel of their obligation under the Uniform Code of Military Justice.
The UCMJ.
Right, the UCMJ. It's the federal law that governs everyone in the armed forces.
Mm-hmm.
And the video was just reiterating the part about the duty to refuse an illegal order.
That's the core of it. The Democracy Docket report makes a big point of this. The video didn't even name President Trump. It didn't issue any commands. It just said, hey, remember this part of military law that everyone learns in basic training?
But the reaction from the White House was, well, it was explosive.
Explosive is an understatement. Our sources say President Trump called it seditious behavior and even suggested imprisonment or execution.
Which is a pretty extreme reaction.
To say the least. So the DOJ, led by D.C. U.S. Attorney Jeanine Pirro, launches a full investigation. They go to a grand jury seeking charges for interfering with the loyalty of the armed forces.
And this is where we get right back to that ham sandwich. Because in the federal system, grand juries almost never say no. It's not a trial. There's no defense attorney there to argue back.
It's just the prosecutor telling their side of the story.
Exactly. But in this case, they returned what's called a no true bill.
Which is the legal way of saying rejected.
It's a flat-out rejection. But it's the way they rejected it that's so stunning. According to the reporting, the prosecutors failed to convince a single grand juror that there was probable cause.
0 votes.
0 votes.
How is that even possible? It seems statistically impossible.
It's practically unheard of. As one legal expert in our notes put it, getting 0 votes is spectacularly difficult. It suggests the evidence wasn't just weak. It was non-existent.
It's like the grand jurors just looked at them and said, are you kidding me? You're wasting our time.
That's the takeaway. 0 regular citizens bought what the DOJ was selling. And analysts are viewing this not just as a legal loss, but as a rebuke, a statement.
So the citizens are acting as a shield here.
That's a great way to put it. They look at the evidence, they look at the political context, and they essentially said, nope, we are not going to be part of a political hit job.
And this is where it gets really interesting. This wasn't a one-off thing. If you dig into the Homeland Security Newswire report, It looks like this is part of a pattern.
It absolutely is. The term the sources are using is overcharging. Taking a pretty minor incident and trying to blow it up into a massive felony just to make a point.
Which brings us to the sandwich, the
Right.
actual literal sandwich.
The sandwich case. This involves a guy named Sean Charles Dunn, who was a former DOJ employee.
So the incident, and I'm not making this up, is that he threw a sandwich at a federal officer. Some of our notes say it was a hoagie.
A hoagie, either way, it's rude, sure. It's assault, technically. Yeah. But that's usually a misdemeanor. You pay a fine, maybe some community service.
But that's not what the DOJ wanted.
No. Under Pirro, they tried to charge it as a felony.
And what did the grand jury do?
They refused.
Oh.
Twice. The DOJ actually went back, tried again to get the felony charge, and the second grand jury said no again.
Wow.
He had to settle for a misdemeanor, went to trial, and he was acquitted anyway.
It really feels like the grand juries are just acting as a common sense filter. They're looking at these cases and saying the punishment just does not fit the crime.
Or that the motivation feels wrong. There's another case in our notes from California with U.S. Attorney Billy Assaley. They tried to indict 38 protesters for interfering with ICE raids. The grand jury looked at the government story and just rejected most of it.
How many did they end up indicting?
Only 7 out of 38.
So that rubber stamp isn't rubber stamping anymore.
Exactly. Grand juries are shedding that reputation. They're asserting their independence. When they perceive that the state is using the law for intimidation, whether it's against a senator or sandwich thrower, they are pushing back.
Okay, but it's not just the juries, right? Because we have to talk about the lawyers bringing these cases. There's a really weird detail in the above-the-law reporting about the team that was prosecuting those 6 Democrats.
Yeah, this gets into what sources are calling the personnel problem at the DOJ.
The brain drain.
Right. There are reports that career prosecutors, the really experienced folks who have been doing this for decades, are leaving the D.C. office in droves.
Or they're just refusing to touch these political cases.
Exactly. They don't want to bring what they're calling garbage charges. They have professional reputations to protect.
So if all the experienced people are leaving, who's left to prosecute?
Well, you have Jeanine Pirro at the top, who was a former Fox News host, confirmed on a party line vote. And because she's losing her career staff, she has to bring in outsiders.
And this is my favorite detail in this whole stack of research. The lead prosecutor on the case against the Democrats, the one that got 0 votes from the grand jury, was a guy named Steven Vander Velden.
Who was a retired local prosecutor from New York.
And for the last 3 years, he has been running a dance photography studio.
That is correct.
I mean, come on. I love a good hobby. I respect the arts, but are we serious? The Department of Justice is trying to indict sitting U.S. senators for sedition, maybe the gravest charge you can levy against a public official, and they bring in a guy who's been taking pictures of pirouettes for the last 3 years.
It sounds funny, but it points to a very serious issue of competence. Federal court is a different league. The rules of evidence are incredibly strict. And get this, the second prosecutor on that team was a former congressional staffer.
With what kind of trial experience?
0 federal trial experience. None whatsoever.
So you've got a dance photographer and a staffer going up against some of the best defense attorneys in the country.
And the result was what experts called a historic bungling. One legal commentator actually compared it to a sobbing toddler watching their balloon drift away.
Ouch!
It's brutal, but it shows what happens when you strip away institutional knowledge and replace it with loyalists or just inexperienced outsiders. The quality of the work completely collapses.
And we actually have the numbers to back that up, right? This isn't just anecdotes.
No, the data is startling. We've got reporting from Reuters and analysis from Glenn Kirshner that basically quantifies this collapse.
Okay, hit us with the numbers.
Under Pirro's leadership, the dismissal rate for cases in the D.C. U.S. Attorney's Office has spiked to 21%.
21%. That sounds really high, but what's the benchmark? What is it usually?
The historical average over the 10 years before her was 0.5%.
Wait, 0.5% to 21%? That's a 40-fold increase in cases getting thrown out.
It's catastrophic in legal terms.
Yeah.
And you have to understand why these cases are getting dismissed. It's not just bad luck or losing an argument.
The sources mentioned the Torres Riley case as a good example of this, the Trader Joe's arrest.
Correct. Federal agents stopped a man named Torres Riley in a Trader Joe's. They searched his backpack, and they found firearms. On paper, that sounds like a good arrest.
A win for law enforcement.
Right. But the judge threw the whole case out.
Why?
Constitutional violations. The judge ruled there was no probable cause for the search in the first place. It was a violation of the Fourth Amendment, the right to be free from unreasonable searches. And this is happening over and over again.
So it's not just that they're bad at arguing in court, it's that they're violating basic constitutional rights to even get people into court.
Precisely. And this is where the really deep, long-term damage happens.
Yeah.
In the legal world, there's this concept called the presumption of regularity.
Can you break that down for us?
Sure. It just means judges generally assume prosecutors are acting in good faith. They assume the government followed the rules, obtained evidence legally, and isn't lying to the court. It's a benefit of the doubt that the whole system relies on to function.
And now that trust is gone.
It's evaporating. Judges are scrutinizing everything the DOJ does now much more closely because the credibility is just shot. When you have a 21% dismissal rate, the courts stop giving you that benefit of the doubt.
They start treating you like you don't know what you're doing.
Or worse, that you're acting with malice.
So you would think, logically, if you're failing this badly, if grand juries are rejecting you and judges are tossing your cases, you would maybe, I don't know, rethink your strategy. Pause a little.
You would think. But the reporting suggests the DOJ is doing the exact opposite. They're escalating.
They're doubling down.
If the system, the grand juries and the judges, won't give them the results they want, they seem to be looking for ways to just bypass the system entirely.
The sources talk about a couple of new tactics here. One is jury shopping.
Right, which is pretty much what it sounds like. If one grand jury says no, instead of accepting that the evidence is weak, reports say officials are instructing prosecutors to just go impanel a new grand jury.
Just keep rolling the dice.
Keep rolling until you get a group that says yes. It kind of defeats the whole purpose of having that check and balance.
It does. But there's another tactic that sounds even more technical and maybe even more dangerous. Charging by information. Can you explain that?
Okay, so this is a procedural maneuver. Normally, for serious crimes, you need a grand jury indictment. The Fifth Amendment actually guarantees that.
That's the constitutional standard.
It is. But charging by information is a way for a prosecutor to formally charge someone without going to a grand jury. Now, in the federal system, you can usually only do this if the defendant agrees to it, like in a plea deal. But the concern here is that the DOJ is trying to find ways to use this mechanic to bypass that community oversight of the grand jury entirely.
So they just skip asking the citizens for permission because the citizens keep saying no.
That's the fear. The Homeland Security Newswire piece draws a really fascinating historical parallel here, all the way back to the case of John Peter Zenker in 1734.
Wow, okay, back to the colonial days.
It's really relevant, though.
Yeah.
Zenker was a newspaper publisher who criticized the British Crown. The grand juries back then, which were made up of local colonists, refused to indict him because they agreed with his criticisms.
So the grand jury worked as a shield. It protected him.
It did. But the Crown didn't give up. They used information to charge him anyway, to bypass the jury. It was a way to crush dissent with the law, basically saying, we don't care what the people think, we're charging you.
And the argument is that the current DOJ is dusting off that same playbook from the 1700s.
That is the accusation, yes. If the grand jury is the shield for the people, they're trying to figure out how to just walk around the shield.
This brings us to the so what of it all. Because this isn't just legal trivia. People are calling this a full-blown crisis.
Senate Minority Leader Chuck Schumer used those exact words, constitutional crisis.
And the Democrats who are targeted, Slotkin, Crow, Kelly, they're not just taking this lying down.
No, they are turning the tables. They've sent letters demanding the DOJ preserve all evidence for what they call anticipated litigation.
They're getting ready to sue the Department of Justice for malicious prosecution.
Think about that. Sitting members of Congress preparing to sue the DOJ for trying to frame them, it shows you just how deep this fracture has become.
It really feels like a shift in how the DOJ is being viewed. It's no longer seen by its critics as this independent body.
It's being viewed as a tool for total submission. That's a phrase from one of the reports.
Total submission. That's a chilling phrase.
It is. The argument is that the administration, and specifically President Trump's retribution agenda, is using the justice system to punish political rivals. The incompetence we talked about, the dance photographer, the bad searches, that's one part of it, but the intent is the other.
It's really a perfect storm. You have the political motivation at the top, you have inexperienced staff in the middle, and then at the bottom you have these grand juries full of regular people just saying, no, we're not doing this.
And that resistance from the citizens is the most surprising variable in all of this. You can appoint the attorney general, you can hire the prosecutors, but you can't really control the 23 random citizens who walk into that jury room.
It does make you wonder, though, If the grand jury is the first line of defense, the shield, as you called it, and the DOJ is now actively finding ways to get around them, what happens next?
That is the big, scary question. If charging by information becomes the new normal, or they find other loopholes to avoid asking citizens for permission, the only thing left is the trial jury.
The last line of defense.
The very last line. But getting to a trial takes months, sometimes years. It costs a fortune in legal fees. It can destroy your reputation. The whole point of the grand jury is to stop the bad cases before they ruin a life.
So if you remove that check,
The power dynamic shifts dramatically. It puts the average citizen in a very vulnerable position. You go from a system where they can indict a ham sandwich to one where they can't even indict a senator to one where they might just skip the indictment altogether.
the rules of the game are changing in real time.
And when the rules change that fast, stability is usually the first casualty.
Well, that is all the time we have for this deep dive. It's a messy, really complex situation, but hopefully we've helped you make some sense of the headlines.
Always a pleasure to dig into the evidence.
Thanks for listening. Keep asking questions, and we'll catch you on the next one.